Order, order. Good morning, everyone. Would everyone please ensure all electronic devices are turned off or switched to silent mode? We now continue line by line consideration of the bill. The grouping and selection list for today's sitting is available in the room and on the parliamentary website. I remind members about the rules on declaration of interests as set out in the Code of Conduct. I also remind opposition members that if one of your new clauses has already been debated and you wish to press it to a division when it is reached on the amendment paper, please let me know in advance. We now come to new clause 24. I call Matt Vickers.
Thank you, Dr. Morrison. It is a pleasure to serve under your chairmanship. The Conservative Party have introduced this clause to ensure the lower tier immigration tribunal will be heard in public. We've seen over recent months the absurd outcomes of some of the cases being heard in the upper tribunal, but we feel it's important to make sure the system is transparent so that the public have full access to the tribunal records at both levels. Examples of recent cases reported by the Telegraph include an Albanian criminal who avoided deportation after claiming his son had an aversion to foreign chicken nuggets, and a Pakistani paedophile who was jailed for child sex offences but escaped removal from the UK as it would be unduly harsh on his own children. A more recent report was that of a Pakistani man who was convicted of sexually assaulting a woman and was allowed to stay in Britain after he claimed he was gay. An Albanian criminal also avoided deportation after a judge ruled that long-distance Zoom calls would be too harsh on his stepson. This absurdity is further emphasised by the case recently heard where a Ghanaian woman won the right to remain in Britain as the wife of an EU national, even though neither she nor her husband were present at the wedding held in Ghana. Despite the lower-tier tribunal stating the marriage was not legal, this was overturned in the upper-tier tribunal, which ruled that the proxy marriage was recognised in law and that registration at the same time as the marriage ceremony wasn't mandatory. The continued abuse of our legal system and the use of human rights as a defence has gone on for too long. For example, a convicted Ghanaian pastor who was deported from Britain for using fake documents should be free to return to the country, the tribunal has ruled. Despite being jailed for using illegal documentation, the individual in question appealed under Article 8 of the Convention on Human Rights, leading a judge to revoke the deportation order, claiming that it was an unjustifiable interference in his human rights. The argument against it may be the number of decisions. However, these decisions are important. As tribunal figures for October to December 2024 show, the first-tier tribunal's asylum appeal backlog increased from 34,234 outstanding cases at the end of September 2024 to 41,987 by the end of December. This contrasts with 58,000 in the first quarter of this year. This is significantly more than the upper tribunal, but it underlines the importance of us knowing what has happened in these cases. Public trust is pivotal when advocating for opposition new clause 24.
I thank the Honourable Gentleman for giving way, and Dr Morrison, it's a pleasure to see you in the chair, bookending our proceedings, I suspect, at the beginning and possibly if we make reasonable progress today at the end. I wonder if the Honourable Gentleman would acknowledge that increases in appeal backlogs are a result of the legacy process which his government undertook, because people who weren't granted in that process have appealed and added to the backlog.
Well, we know that significantly more people are arriving in the country. In fact, since the election, their numbers arriving illegally are up 29%. The number of people staying in hotels up 29%. The more people who arrive, the less people who... Well, we're actually removing less people who arrive by a small boat now. The more people arrive, the more these backlogs will become an issue. But with regard to this particular clause, I think the transparency in these tribunals is essentially important. I think... Yeah.
I'm really trying to get my head around this clause. Why would decision-making in public be different than decision-making in private?
Public trust in these decisions is completely and utterly broken. The answer to that is not to allow a good chunk of them to go unseen by the public. Actually, the public deserve to see. The people making the decisions deserve to be held to account. We need to ensure that the law is fit for purpose. We need to see the impact of the Human Rights Act, the impact of the ECHR, and it needs to be there for all to see. Public accountability, transparency is a good thing, and the taxpayers out there who fund all of this have the right to know what's going on at any level in those tribunals. Yeah.
I thank the Honourable Member for giving way. It's a pleasure to serve under your chairpersonship, Dr Morrison. I agree with him that there is a lack of trust in our immigration and asylum system, but would he not agree that actually the cause of that is not the conduct of courts in public or private, but the backlogs that are being created and the inability of the Conservatives to tackle the problems in our immigration and asylum system? And would he not also reflect on the fact that the Conservatives in government have the opportunity to introduce this change while in government but chose not to? And is he perhaps just playing a little bit of politics?
I think, do you know what, we've seen what's happened since the election. We won't go into the fact that numbers are up significantly, the number of people arriving by small boat is down significantly, but actually I think regardless of when it's changed, here is an opportunity with a piece of legislation to change this, and I think the trust that the public have in the system is completely battered by these decisions, and so it is right to have that transparency. The answer to building public trust is not to hide a good chunk of what's going on, but actually let more people see it. Have the light of day will be very good at getting rid of some of this toxicity and holding people to account and ensuring that the legislation that we have tomorrow is fit for purpose. We should be held to account as parliamentarians for the legislation that we're putting forwards. We should be held to account for its consequences, including in these tribunals that are making so many decisions on these cases. Public trust is pivotal when advocating for opposition new Clause 24. It transforms the debate from a dry procedural tweak into a fundamental issue of democratic accountability. The British public's faith in the immigration system has been battered by the bizarre tribunal rulings highlighted earlier. Decisions hidden behind closed doors that defy common sense and insult victims. By mandating public hearings at the first-tier tribunal, we can signal that justice isn't just for claimants, but for taxpayers who fund it. Yeah.
Honourable Member for giving way. Big question here is, he's got a lot to say in opposition. Why didn't he do this when the opposition was in government?
Well, there's lots of things that we were doing. There was lots of I'm sure we'll go on to some of the progress that was being made, whether it be that Albania agreement that's took thousands and thousands of people back to Albania and reduced the number of people, that deterrent that stopped people setting off in the first place. It was real progress. This bill, and the reason we're sat here today, is the opportunity about what comes next. It's the opportunity to shape what comes next and what impact that will have on the number of people coming across that channel, what impact that will have on public confidence in our court systems. This is what we're here for. That's why we've bothered sitting here for so many hours, to ensure this legislation that goes forward tomorrow is fit for purpose. Well, we'll see how much longer we get to sit. Time will tell. But I'll move on. Yeah, go on, yeah.
He's making a very powerful point here about the importance of restoring trust. And I think, to be fair to the Honourable Member, he's been making this point for many years. On the 20th of July 2021, he said on the debate on the Nationality and Borders Bill, our asylum and immigration system is not fit for purpose. It lines the pockets of criminal gangs and people smugglers, and it is not fair on genuinely vulnerable people who need protection. It is also not fair on the British public who pick up the tab. Now, I agree entirely with the Honourable Gentleman about what happened in 2021, 2022, 2023 and 2024, and in fact the years before that. So would he agree with 2021 Honourable Member for Stockton West that in fact the cause of the mistrust in our asylum system is the management of it, not what you're trying to achieve here?
I'm glad he's a fan. I made an effort today with the tie. I think I was speaking as much common sense then as I am today. But I agree. It doesn't work. That's why we're here. That's why hopefully this thing will make a difference. That's why we're trying to improve it. And that's why I think we should have transparency in these tribunal outcomes. The argument against it may be the number of decisions. However, these decisions are important. As tribunal figures for October to December 2024 show, the first-tier tribunal's asylum backlog increased from 34,000, I've gone completely back on myself, decisions hidden behind closed doors that defy common sense and insult victims. By mandating public hearings at the first-tier tribunal, we can signal that justice isn't just for claimants, but for taxpayers who fund it and citizens who live with its consequences. Transparency exposes these absurdities, has the potential to curtail judicial overreach and could reassure a sceptical public that the system prioritises their safety and fairness over secretive leniency, because trust, once lost, is hard to rebuild. It's only right that the general public, who foot the bill time and time again for these cases, are allowed to fully understand what their money is being used for. It's only right that the public can see these sessions so that there is a place for scrutiny and accountability. It's only right that such a shameful abuse of the UK's legal system be exposed to the taxpayers of this country. Thank you.
Immigration Tribunal hearings in public.
The question is that new clause 24 be read a second time. Mike Tapp.
Dr Morrison, it's a pleasure to serve under your chairmanship. The member for Stockton West has made a creative argument. I'm going to try and bring some sense to this. First, we have to look at what this would actually do for the country and our judicial system should it be implemented. Public hearings could expose vulnerable individuals, including victims of persecution or trafficking, to undue public scrutiny, which could deter genuine applicants from seeking justice. There's also security risks here. Sensitive information about applicants' backgrounds, including details that can endanger their families in their home countries, could be exposed. There's also the risk of the legal system being overloaded further, given what we've inherited, as the increased public interest in the hearings could then lead to more appeals and challenges, which will cause more delays and inefficiencies in the system. And finally, it's simply unnecessary, as courts do already have the discretion to allow public access when appropriate, but this amendment would remove vital judicial flexibility. Thank you, Chair.
Good morning, Dr Morrison, and thank you. It's a pleasure to serve with you in the chair today. After years of broken promises, it should come as no surprise that the public does not trust politicians in Westminster when it comes to immigration. This distrust is compounded by the regular reports we see of individual cases in the immigration system, of which the most shocking and nonsensical are often those of foreign criminals allowed to remain in this country due to human rights rules. The system is broken. It has been broken for many decades, and this is now plain to see. Our basic decency, our desire to do the right thing, is exploited by paedophiles, rapists, terrorists, and hardened criminals who threaten not just individual members of the public, though that is terrifying enough, but the broader social fabric of our country. And we only know this, these news reports that we read are only possible because upper tribunal judgments on asylum and immigration are published at regular intervals. The publication of these judgments allows everyone in the country to see what tribunal judges have decided in asylum, immigration, and deportation cases. And, crucially, it allows us to scrutinise both their decisions and their reasoning. We can see why the judgments were made and what that says about our laws, and decide for ourselves whether or not we think that is right. Judges are not accountable to the public, but this transparency allows everyone to see our laws in action and to form a view about whether those laws are the right ones. But these upper tribunal judgments do not tell the full story. All immigration and asylum cases are first heard by a lower tier tribunal, the judgments of which are not made available to the public. Unless the initial decision of the lower tier tribunal is appealed, the public does not get access to the details of any given case, ever. Given the absurdity of the cases that we do hear about, many members of the public will rightly be wondering what is happening in those cases we don't see. If we want to restore public trust in the immigration system, we must restore transparency. Publishing the decisions of lower-tier tribunals is not the biggest or most consequential change in the grand scheme of our broken immigration system, but it is a meaningful one. The public has a right to know about the way that our tribunal system works. The public has a right to know about the rules that judges are using to make fundamental decisions about immigration and asylum, fundamental decisions about who can be in this country and why. And the public has a right to see how those rules are applied in practice and decide for themselves whether that is right or wrong. whether or not that serves Britain's interests. That is why we are moving this amendment today, and we sincerely hope that the government will consider making it part of this bill.
Dr Morrison, it's an honour to serve on your committee. I don't really see how turning border security on a case-by-case basis into a public discourse is beneficial to the process, either for those administrating and presiding over the hearings or for those who are going to be subject to the tribunal process. I accept there is an argument for greater transparency, but given the circumstances of people's arrivals at our borders, where they're fleeing trauma and in a vulnerable state, I feel it's inappropriate to parade the lives of asylum seekers in the public domain. I have every faith that the provision in this bill will serve to create a robust system that is effective and accountable, and that this amendment would add nothing to the overall strength of the bill. The honourable gentleman is saying that trust has been lost in the asylum system. I think it's going to take this bill and this government to bring that trust back. Thank you.
Minister.
Thank you very much, Dr Morrison, and I have to compliment, since he raised it, the honourable gentleman from Stockton West on his tie, and I think the honourable lady for Weald of Kent seems to have good taste in the colour of her jacket, and I promise that's the last fashion statement I'm going to make in the proceedings today. On new clause 24, we agree that accountability and transparency is absolutely vital for building trust and credibility in the immigration system. Under Rule 27 of the Tribunal Procedure, First Tier Tribunal Immigration and Asylum Chamber Rules 2014, note the date, 2014, the presumption already is that hearings at the First Tier Tribunal must be public unless the First Tier Tribunal gives a direction that it, or part of it, is to be held in private. Indeed, the majority of hearings at the First Tier Tribunal are public. However, there are sometimes appropriate reasons for a hearing not to be public. For example, hearings may be held in private to preserve confidentiality in respect of sensitive medical details, or to protect the privacy of a victim of a serious crime, for example, of a sexual nature. It may also be done to protect a party or a witness from duress. This is precisely why the Tribunal Procedure Committee has a broad discretion to determine what practice and procedure in the First Tier Tribunal will best support the overall interests of justice, and why the judiciary have a range of case management powers under the Tribunal Procedure Rules to decide how individual cases should proceed. And those tribunal powers were published and written when the Honourable Gentleman's party was in government in 2014. And it's totally expected that judges have a wide range of discretion dealing with these sensitive kinds of issues. In terms of the rulings of the First Tier Tribunal being available to the public, currently judgments of the Immigration and Asylum Chamber of the First Tier Tribunal are not routinely published, and the decision whether to publish a judgment is a judicial one. However, members of the public and the media can apply to the tribunal for a copy of the judgment in a specific case. And I know the Lord Chancellor will continue discussions with the judiciary on how we can bolster accountability and transparency to build public confidence, but I can't help feeling that perhaps there are certain people who might work for a certain newspaper who are getting to the end of their search engines for absurd cases that they can publish in their newspaper and want to have a whole new database to search. But really, if they want to bring some of these issues out into the open at the First Tier Tribunal, perhaps they should send some reporters to listen to the case or apply on an individual basis for this to be published, and perhaps that might be a way of assuaging their ongoing interest in these issues.
Thank the Minister for her opinion. We stand by this. We want to see greater transparency. We think this is an opportunity to do just that and allow the public to see what it is that isn't going on, and we would like to move it to a division.
New clause 24 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division.
Jade Botterill.
No.
Dame Angela Regal.
No.
Tom Hayes.
No.
Katie Knight.
Aye.
Martin McCluskey.
No.
Siba Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
The ayes were 2, the noes were 12, so the noes have it. The noes have it. Unlock. New clause 25. We now come to new clause 25, and I call Matt Vickers.
Thank you, Dr. Morrison. The Conservative Party is clear that the right for immigrants to remain indefinitely in the United Kingdom and to acquire British citizenship should be a privilege that is earned, not an automatic right. These privileges should be reserved for those who have made a real commitment to the UK. New clause 25 would ensure the period before anyone can claim indefinite leave to remain would be increased from 5 to 10 years. We also believe that new conditions should be added to ensure that those applying for indefinite leave to remain have not claimed benefits or relied on social housing while here on work visas. Those claiming indefinite leave to remain must also be able to demonstrate that their household would be a net contributor and that they do not have a criminal record. It's only right that individuals prove that they have made a positive contribution to the United Kingdom and that their contribution to society is justified. For too long, the United Kingdom has been seen to have an open-door policy that has been abused. Enough is enough. The 10-year rule would prove commitment. 5 years lets you settle. 10 years lets you prove you belong. It's enough time to learn our language, adopt our values and pay your dues.
Thank you to the Honourable Member for giving way. As part of the policy proposal, which I think has emerged before the Leader of the Opposition has actually set in train her own new policy commissions, including one on immigration, so it's good to get a teaser today. Would there be a requirement that every 30 months a person who would seek to apply for indefinite leave to remain after 10 years would have to apply for LLR? Would there be a requirement that every 30 months they would have to do that?
You've got me. I was hoping you were going to espouse some more common sense from Hansard that I'd contributed. The answer is you've got me.
Doesn't know.
Well, we've said 10 years. That's a principle, actually. Yep.
In which case I might be able to help it. So in the IPPR report on called A Punishing Process, which listens to the voices of migrants and asylum seekers and refugees navigating that 10-year process, but also people who seek to settle illegally, and also looks at the data. It talks about some of the administrative costs and difficulties that are involved. So would he commit to going away and finding out the following information as part of the Leader of the Opposition's new commission on immigration? Would he be able to come back with an assessment of what the true cost to the Home Office would be of an application for individuals every 30 months for LLR? And would he also be able to tell me whether he'd maintain the same requirements that people have to pay £2,608 as an adult, £2,223 for a child for visa fees? Because one of the concerns of this report is that poorer people often get pushed into greater poverty by having to apply every 30 months.
We have processes in place that determine that do come with a cost. But you know what? The cost to the British taxpayer of allowing this thing to go on unabated is that much greater. And I'm sure I will come on to it in due course. But you know what? There are processes in place. There are costs attached to that. But there are huge costs attached to allowing these people indefinite leave to remain on shorter terms than we are suggesting.
Can the Honourable Member give way again? Could he tell me what the evidence base is that supports that assertion?
There is huge costs. I will come to exactly what the cost is going to be in the next few years of the number of people who are about to gain indefinite leave to remain. Could I give you the name of the report? No, I wouldn't give you the name of the report. The 10-year rule would prove commitment. 5 years, let's use it, we've been there. As the Shadow Home Secretary, the Right Honourable Member for Croydon South, said, a British passport is a privilege, one that's been debased by benefit tourism, for too long. The Conservative plan gets it right, making sure that those who pay their way get to stay. The Prime Minister bizarrely does not appear to think that British citizenship is a pull factor, so much so that the government is seeking to repeal swathes of the Illegal Migration Act 2023 introduced by the previous Conservative government. In doing so, the government scrapped rules that meant almost all of those who have entered the United Kingdom illegally would not be entitled to British citizenship, and that asylum seekers would be treated as adults if they failed to take age tests. These were common sense policies, and we're calling on all parties, but especially the government, to support this new clause. We need to ensure that everyone who comes to this country is willing to contribute and integrate into our society. Yeah. Our countries are... Go on, carry on. Yeah.
Thanks, Honourable Gentleman, given way. It's a pleasure to serve under your chairship. Madeleine Albright, the former US Secretary of State, first of all was a refugee in the UK, and she said, in Britain, they say, you're a refugee, you're welcome, how long till you leave? Whereas in America, they said, you're a refugee, how long till you become a citizen? And don't you think that the problem the last government made was it moved to a very high churn model of migration, with huge numbers of people coming in, working in low-paid jobs, not integrating, and then leaving and more people coming in? And actually, we want to incentivise people to learn the language, engage with our institutions, follow our rules, which means pathways like this are really important, not the model we've seen for the last 14 years.
Well, I think the principle here is that we're saying you will get indefinite leave to remain, not after 5 years, but after 10 years. We've also had the debate already about British citizenship and what that means and all of the benefits that come with that and all the costs that are attached to it for the taxpayer. So I think this is right. I think the principle that if you have to stay here, you've been here longer, you have to have earned your keep, you have to have contributed, you have to be integrated properly. I think 10 years allows that. I think this is the way forwards. Yeah, I stand by it. Yeah.
I thank him for his patience in allowing me to intervene again. Is it not fair for this government to only accept amendments when the detail of those amendments are actually known and worked up? And is it therefore unfair for the Honourable Member for Stockton West to be putting forward an amendment when he hasn't worked out the details of what the implementation of it would look like?
The details and the needs for people to engage with the authorities is what's already in place. This is literally about saying 10 years instead of 5 years. We're not saying there's no part in this amendment that amends what already exists in terms of the responsibilities on those migrants to account for themselves during those 5 years or those 10 years. There's no suggestion of any change in that. It's beyond what we're amending as the clause. If we wanted to change that, there's certainly debate to be had, and there's probably opportunities to bring forward amendments to that, but that's not what we're proposing here. We're proposing to carry on increasing that time from 5 to 10 years. Our country is our home. It's not a hotel. We can guess what the government's response to this might be, more deflection and criticism. However, they must remember they're in government and now have a duty to protect the British taxpayer from unnecessary costs. If they do not act, every UK household is forecast to pay £8,200 as a result of between 742,000 and 1,224,000 migrants getting indefinite leave to remain in the next couple of years. The government must act to ensure that everyone who stays in the country is a net contributor. It may interest the government to know that changes to indefinite leave to remain have happened before and can and should be happening again this time. In 2006, under the previous Labour government, the Home Secretary at the time extended the time required to obtain indefinite leave to remain from 4 years to 5 years, an extension which applied retroactively to those already actively pursuing indefinite leave to remain. It's hoped that this government will be able to take such a bold move and support new Clause 25. And let's be crystal clear, before the accusations can be thrown around, our new Clause 25 isn't some cold-hearted exercise in exclusion. It's a robust, principled stand for expectation, a line in the sand that says living here, staying here, calling Britain your home, comes with a reasonable cost. And that cost isn't just measured in pounds and pence, but in commitment, in responsibility, in proving you're here to lift us up, not weigh us down. In a recent study undertaken by the Adam Smith Institute, it found that according to figures produced by the OBR, the average low-wage migrant worker will cost the British taxpayer £465,000 £1,000 by the time they reach 81 years of age. It's clear that opening the ILR door to millions of new migrants will impose a considerable and unwanted financial burden on the British taxpayer for decades to come. The report itself explores the fact that this is an opportunity to reform indefinite leave to remain rules, something new Clause 25 seeks to do. Taking such steps would help mitigate the long-term fiscal burden of low-skilled migrants who are unlikely to be net contributors to the public purse. A refusal to back this clause isn't just inaction, it's a choice to prioritise the untested over taxpayers, to keep the welcome mat out while the costs pile up. We say no. This is our home, and we expect those arriving to treat it as such. Thank you.
Qualification period for indefinite leave to remain in the United Kingdom.
The question is that new clause 25 be read a second time. Pete Wishart.
Thank you very much, Dr Morrison, and it's a pleasure once again to serve under your chairing this morning. I have to say, when I look at the Tory amendments in their totality, they're quite frankly an absolute and utter disgrace, and it's as if they've learned absolutely nothing from the Rwanda debacle and the Illegal Migration Act. Some of the amendments that we're going to be debating today are simply heinous, lacking in any reasonable standard of compassion and empathy. And what a country they would create, one devoid of human rights, international protections, where people are simply othered and deprived of any rights whatsoever. Some of the most desperate and wretched people in the world to be denied and booted out. Now, I used to say that the Tories would never beat reform in the race to the bottom, but looking at the collection of amendments we've got today, they're going to give it their best shot possible, and it just might be possible that they will out-reform our reform colleagues in the House of Commons. These amendments are not only terrifying, they are ludicrously unworkable and blatant political grandstanding designed to appeal to the basis of instincts. And I know we have the grim task, Mr Morrison, of having to look at them one by one today, and I just hope that members of the committee will reject them totally out of hand. Now, new clause 25 was the first one that they brought, and of course this was raised in a blaze of publicity as the end of the self-denying ordinance from the leader of the opposition when she was announcing her new immigration policy, which I understand has been changed and finessed over the course of the past few weeks, but it's still as grotesque underneath as it started at the very top. Now, they don't believe that British citizenship should be a privilege. They believe that British citizenship should be virtually unobtainable, and the strongest possible tests must be applied before anybody is ever going to get the opportunity to call themselves a British citizen. And they're totally and utterly self-defeating. What this will do is it will currently apply to work-based visa holders, skilled workers, global talent who can apply for ILR after 5 years. And extending this to 10 years could deter highly skilled workers and investors from coming to staying in the UK. It may lead to workforce instability, particularly in sectors reliant on international talent. It would also disadvantage certain migrants and people who have lived legally in the UK for 10 years but do not hold the listed visas. Mr Morrison, this is an unworkable, crazy situation that can only be self-defeating, have a massive impact on our economy. It would create a massive disincentive to the very people that we need to come into the UK to fill some of our skills gap, and I hope it's roundly rejected this morning.
Joe White.
Thank you, Dr Morrison. It's a pleasure to serve under your chairpersonship. What should never surprise us on this side is the audacity of the Conservative Party, which now exists in a state of amnesia following the previous 14 years of failure, collapse and chaos. And let's take a moment to remind the honourable members of their failed promises. David Cameron and his general election campaign of 2010 is a good place to start, when he said his government would reduce net migration to the tens of thousands. At that point, the net migration figure stood at 252,000. In 2011, he went further, saying that his target would be achieved by the 2015 general election. No ifs or buts, he said. But when the ballot boxes opened, numbers had risen to 379,000. Then along came Theresa May, and in the snap general election of 2017,
net migration stood at 270,000, aligned with an election pledge to get net migration down to the tens of thousands. But by 2019, the number had risen to 275,000. Next, we have Boris Johnson promising yet again to bring down net migration, saying that he reduced the numbers of unskilled workers coming into the country. In 2020, net migration had again risen to 374,000, and with the labour shortages following COVID, more visa routes had to be urgently opened for lorry drivers, bus drivers, the hospitality sector, and for high-skilled roles, after the Conservative government failed to invest in British workers. And then began the small boats crisis, with the Conservative government failing to do anything to stop its source, its methods, or the routes. And under Rishi Sunak, they came up with the wizard idea that by sending a group of arrivals to Rwanda, it would stop the boats. Well, we all know the outcomes of that failure, with 80,000 arriving on small boats during that period. By June 2024, net migration stood at 728,000. And now we have the leader of the opposition wanting to act tough on migration. With their recent history, how can anyone believe a word that she says? All credibility is gone, and this government is focused on sorting out their mess. In my view, the new Clause 25 is yet another wheeze to speak big, but do little.
Thank you, Dr. Morrison. And how could I begin my remarks without repaying the Minister's kind words about my clothing? This is one of my favourite jackets, and I'm delighted to see that perhaps it might also be one of hers. It is no secret, as the Honourable Member for Bassett Law has just set out, that previous governments of different parties have failed the British public on immigration. The level of immigration to this country has been too high for decades and remains so. Every election-winning manifesto since 1974 has promised to reduce migration. As my right honourable friend, the member for North West Essex, has said, the last government, like the governments before them, promised to do exactly that. But again, like the governments before them, it did not deliver. And because of that failure to deliver, the British public may face a bill of more than £200 billion in the years ahead, unless we change the rules around settlement. Under current rules, after just 5 years in the UK, migrants on work or family visas will become eligible for indefinite leave to remain, or ILR. If they are successful, and 95% of ILR applicants are, they are entitled to welfare, to social housing, surcharge-free access to the NHS, and more. According to the Centre for Policy Studies, some 800,000 migrants could claim ILR over the course of this Parliament. Given the profile of those who are likely to qualify, this could come at a lifetime cost of £234 billion. Yes, we'll gladly give it.
I slightly coughed and also laughed at the same time, partly because I think she anticipated the point I was about to make. I really will put this back on the record, as I have done consistently, which is that, and she may well have more information to come back with me, to me with, and I will therefore come back to her. But that report is flawed. It has skewed information. This is the Centre for Policy Studies report. It is using assumptions which are unreasonable, and the financial modelling which ensues is therefore unreasonable. And as a consequence, it feels to me like the Centre for Policy Studies and the Honourable Member is reaching for a very large number in order to create the impression that there will be a very significant financial burden. Now, there's two additional points I would make. The first is that even if it were the case that that report relied on reasonable assumptions and therefore the modelling was correct, this is a Boris wave that was caused by her government. And I acknowledge that she's nodding her head and she affirms that, and I welcome actually in her speech that she has so far acknowledged the failings of her own government. The second point that I would make here is that it's making some very big assumptions about the future behaviour of the people presently in our migration system and in our country. And what I would say is that that is not a wise move to take, particularly when she's extrapolating, I think, 235 to 240 billion across a very long timeline, when in fact, if you were to break it down on an annualised basis, even using their flawed assumptions and flawed modelling, it would be a far smaller figure. So I think we do need to have some integrity in the data that we use. And would she agree?
Thank you, Chair, and I thank the Honourable Member for the intervention. As Professor Brian Bell said in evidence to this committee, which I think is a session that the member has referred to a couple of times, it is actually extremely difficult, I quote, to work out the fiscal impact of migration. Clearly, that is true. Essentially, forecasting the lives and futures of millions of people over decades is obviously going to have a substantial margin for error. The only way to avoid this would be not to try to do it in the first place. I have asked the Home Office repeatedly over several months whether anyone in that department or anyone in any other department, indeed anyone in government at all, is attempting to forecast the cost to the public purse of ILR grants that will come in this Parliament, and I am yet to receive an answer. That says to me very clearly that nobody in government is thinking about the impact this will have and how much this will cost. When they do, I will happily use those numbers. Until and unless that happens, the modelling from the CPS is the best that we have. In fact, it is all that we have. I will a second time.
And this is my last intervention on this point. I take the point that she's making entirely there. But while she may say it's the best, does she not acknowledge that it has deep fundamental flaws in it? So even though it may be the only, it may therefore be the best, it still isn't, on the strength of what's in that report, worth considering and using in parliamentary debate.
Thank you, Chair. I have already acknowledged that the margin for error is massive, and that is clearly true. If everything that the Honourable Member is saying is correct, what I would like to see is government figures to replace those, and I think that that's a reasonable request. That amount is equivalent to £8,200 per household, or around 6 times our annual defence budget. This is not just about money, but also capacity. Our public services are very clearly already overstretched, and this could push them to breaking point. If we accept that previous governments have failed on migration, as we should, then we should do everything in our power to limit the long-term impacts of that failure. That is why the Conservatives are proposing to extend the qualifying period for ILR and to reform settlement rules to ensure that only those who are genuinely likely to contribute will be eligible for long-term settlement. This will give us an opportunity to review visas issued over the last few years. Those who have come to this country legally on time-limited visas and who have subsequently not contributed enough or have damaged our society by committing crime should be expected to leave. The Prime Minister has said repeatedly that the levels of immigration under the last government were wrong and that it was a mistake to allow so many people to come to the UK. This amendment would allow the government to limit the long-term consequences of that mistake. So why would they oppose it? It is not too late to change our rules around settlement. By refusing to extend the eligibility period for indefinite leave to remain, the government is actively choosing to saddle the British taxpayer with a likely bill of hundreds of billions of pounds. On this reform and the many others required to our migration system, we must make difficult decisions. Those decisions may be painful, especially in the short term for individual people, families or businesses, but that is the only way for any government's actions to match their words. The public has had enough, and rightly so. The Honourable Member for Bournemouth East talked about LLR, limited leave to remain, which on the existing 10-year route must be applied for every 2.5 years. This is the case only because the 10-year route as it stands now, by design, is for those not on eligible visas. The 5-year route, which we are here proposing to change, is exclusively for those on eligible visas, and therefore I cannot see within the existing rules why there would be a requirement, or any requirement for LLR applications. I hope that offers him some reassurance.
Thank you, Chair. The amendment is not in keeping with the provision outlined within the bill, which primarily focuses on border security through new and strengthened law enforcement powers, providing intelligence with the means to address organised immigration crime. Equally, I fundamentally disagree with the context of the amendment. Section 2 of the amendment relates to existing legislation whereby the qualification for indefinite leave to remain applies to people on skilled work visas, scale-up worker visa, entrepreneurial or investor visa, innovation founder visa, UK ancestry, or someone with a partner who holds citizenship, which outline for the most people contributing to our society through work. I feel that if someone has been living and working here in a skilled role or innovating in our country for 5 years, possibly even supporting job creation, that this is long enough for someone to identify Britain as their home. There'll be friends, community networks, and in most instances, they are boosting our economic productivity. Increasing the qualification as set out in this amendment would move the goalposts on skilled workers after years of contribution. Bringing the conversation back to the purpose of this bill, the focus should be on those entering the UK illegally and those engaged in organised immigration crime, not the construction workers, nurses, doctors, investors and business owners in Britain on work visas.
Thank you, Chair. I'll speak briefly. I do welcome the Honourable Member for Weald of Kent in clarifying what the Conservative Party position there is on this amendment. But in clarifying, it also raises further questions, and I wonder whether she would respond on the spot. So, if there is no requirement for an individual every 30 months in that 10-year period to pay $2,608, or for a child to have its visa fee of $2,223 provided to the Home Office, how will the Home Office fund so much of its work? Because actually, the fees that are paid for adults and children's visa fees are a significant financial contributor to the Home Office's budget, if I may. And that's particularly important because actually the Home Office has had to borrow from the ODA budget in order to fund asylum hotels. So I do worry that there's going to be a significant financial gap here, and I wonder if she could clarify what her costings are.
Thank you, Judge Martin. Happily, I think perhaps the Honourable Member for Bournemouth East is eliding two different routes. So at the moment there is a 5-year route, which is for people on eligible visas, and a 10-year route. The 10-year route is the route that has LLR requirements to be applied for every 2.5 years, and that's the route that generates the fees that he's talking about. Under this amendment, that would not change. We're only talking about proposing changes to the 5-year route. The 5-year route at the moment does not have LLR requirements because it is for people on eligible visas. So the income for the Home Office from the same people should be no different under the amendment that we're proposing. I hope that that's clear.
I'm happy to accept that clarification, and if that is in fact correct, then I would look forward to seeing more information about this particular policy and what the financial costs would be involved and what the financial benefits would be. I will lead on to one final point, which is to echo the point which was made by my honourable friend for Edinburgh, Eastern Musselburgh, which is around the importance of settling. And actually, if we talk here about the financial costs involved, it is going to be more costly to our country and to our public services if somebody is having to go through many years of unsettled status. It's going to be harder for them to actually have all the infrastructure and all the anchors in place in their society that they need. As a consequence, I would love to know whether the Conservatives have done any sort of modelling of what the impact would be of increasing the limbo that somebody would be living in, and whether, as the IPP report that I referenced earlier mentions, the cost to public services where people may find themselves homeless, they may find themselves with difficult mental health conditions, they may find themselves unable to take their child to the school that they want to and have to travel significant mileage. So she and I share the desire for integrity of data, for a greater availability of data, but in proposing this amendment, I wonder whether she has access to any of that information. And I would happily take an intervention.
Thank you, Dr. Morrison. I will come back only briefly. I think, if I have properly understood the Honourable Member's question, he is asking what we think the impact is on the number of people who would still apply for ILR after 10 years. He's nodding. So part of what we are trying to say by extending this time is we feel that a person's commitment to the UK before they apply for settlement should be longer than 5 years. So if those application numbers go down because people feel that they don't want to commit for 10 years before getting settlement, that is something that we are happy to accept as part of the amendment. It seems from the numbers that we have at the moment that the number of people who would apply over an extended period of time would go down because there would be fewer people who would qualify under the rules that we are stipulating. The reason that they wouldn't qualify is because they aren't making a sufficiently significant contribution to the public purse over that period of time. So our calculations are that all of those lost applications would be net fiscally positive.
Thank you. In which case, Dr. Morrison, I will only close with saying that actually the Home Office data shows that you don't see that drop-off of people. You don't see people leaving the country as they have to wait longer for their status. What they in fact do is try and get that status by serving within our country and in our economy. The Home Office data, which is publicly available on gov.uk, each year records what the stay rate is and what the departure rate is. So I'm not sure that this particular amendment and the policy within it is going to achieve the goal that she's seeking to achieve.
Thank you, Dr. Morrison. I totally take the Honourable Member's point, but I think he is perhaps answering a slightly different point. What we're saying is that the combination of the extension of time and the change in criteria would lead to lower applications. It's not so much about a choice on the part of the individual migrant, but a structural change within the system.
And the very last point I make is, I understand what she's saying, but that's not what I was making the point about. I think actually this would not be an incentive for people, or deterrent for people to leave the country. I think, in fact, you would still see people remaining in the country, and all of the health impacts that I was describing and the costs to the public purse, all of the limbo that people would be experiencing and their inability to settle will still create a financial and fiscal drag.
Thank you, Dr. Morrison. It is indeed a pleasure to serve under your chairship and make a few remarks at the end of this extremely interesting debate, and to make a few general comments first, and then perhaps some more detailed comments on the proposal put forward by the opposition. Just to repeat, I think, some of the points that the Shadow Minister said, I do think it is worth restating them. He said that for too long we've had an open door policy that is open to abuse. He also said that we should remember that we're in government. Dr. Morrison, what I would say is he's absolutely right that the Tories did lose control over our immigration system, and we don't need reminding about that, nor do we need reminding that we are in government clearing up their mess. And indeed, the context for quite a lot of the debate today has been the massive backlogs that have built up in every part of the system, the failure to have controls over our system and levels of abuse, and indeed the fall in returns that we saw for those who have no right to be here. And it would, I think, be worth also mentioning that the steady increase in settlement grants since 2017 does reflect high levels of migration in previous years. And it's almost as if we have a situation where the Tories are attempting to close the gates to the field, where the horses have long bolted, and everyone else is now picking up the pieces. And I do think it is worth correcting some of the impressions that he gives about our policy, because we agree that settlement in the UK is a privilege. It is not an automatic entitlement. But we also understand that the immigration system needs to account for people in a range of circumstances beyond those specified in this amendment. And we also recognise and value the contribution that legal migration makes to our country, and believe that the immigration system needs to be much better controlled and managed. Now, the Honourable gentleman put forward this amendment, but it is worth also saying that provisions for settlement are set out in the immigration rules. So in fact, this is not the correct legislation really for debate about requirements for settlement. What we're doing with this bill is to strengthen our borders, is to go after the smuggling gangs, the criminal smuggling gangs that have caused so much damage to the lives of migrants already, daily putting lives at risk, and to secure our borders from systemic abuse. Now, it is the case that this amendment would restrict settlement in the UK to a handful of economic routes and to partners of British citizens. There are other routes to settlement in the current immigration system that would therefore be excluded from settlement should this amendment be accepted, including settlement for refugees. And the Honourable Shadow Minister may have a view about, for example, a situation facing an Afghan interpreter for the British Armed Forces who put their lives at risk, who was evacuated to the UK after the chaos that we saw in Kabul in 2020, was then put up in taxpayer-funded accommodation after arrival in the UK. And under these proposals, correct me if I'm wrong, but they would be banned from ever settling in the UK. And it is important that we understand, and the argument made, I think, is right about settlement in the UK being a privilege. And it's right because it does convey significant benefits, including the right to live permanently, have access to work and study and public funds, and a pathway to citizenship. But we also do have rules and processes to recognise the expectation, therefore, that people should serve with a period of temporary permission before being eligible to apply for settlement. And there are a range of periods of time that people need to spend in the UK before they can qualify for settlement. Many of these are 5 years, with shorter period for exceptional routes. And the honourable member didn't lay out what his view would be on some of those specialised routes, which may offer a shorter path to settlement. For example, the global talent and innovator founder routes, allowing settlement within 3 years, helping the UK attract the best talent from around the world, and rewards those who are working in business who are making some of the greatest economic contributions. So it does feel, while wanting to quote from the Centre for Policy Studies and the Adam Smith Institute as the most important references on these debates, it isn't really thinking through how we think about the immigration system as a whole, how we think about it being fairer, more controlled and managed, and how we make sure that it recovers from the chaos that the last government left in it. And indeed, as the honourable member will know, the government will also be setting out its approach to immigration and how we bring net migration down, and how we link skills policy with visa policy, so we reduce our dependence on recruiting from overseas, and we will be setting out that coherent approach to what a future immigration system needs to look like in a white paper coming out later this spring.
Thank you. I am stunned, shocked. In fact, I can't believe that the SNP are less than enthusiastic about our amendments. The Honourable Member for Bassett Law and Feltham and Heston were keen to talk about records. At the risk of repeating myself, immigration is too high. Previous governments have failed to solve it. I would love for the government to succeed in doing so, but I'm not convinced, particularly without a robust deterrent. I'll say it again. Since this government were elected, the number of people arriving here illegally is up 28%. The number of people in hotels is up 29%. 8,500 more people in hotels and communities across this country. And less of those people arriving by a small boat are being returned.
I thank the Shadow Minister for giving way. Does he also agree that returns are almost 19,000 to the end of January, up around since we came into government, up around a fifth on what they were 12 years before, including an increase of about a quarter on enforced returns? He may want to talk more about
I'm sure you agree that a large part of those are voluntary returns. I'm sure a large part of them also make benefit of some of the agreements that were made by the previous government. But actually, when you talk about the people arriving here illegally on small boats, the number is down significantly in the last 2 quarters since this government came to office. That's a fact.
I'm reading from the Home Office here, who say comparisons of arrivals between months in different years may be affected by differences in weather conditions. As a result, we do not advise making comparisons between shorter periods where arrival numbers may fluctuate considerably. The Home Office also comments that financial, social, physical and geographical factors may influence the method of entry individuals use and the type of individuals detected arriving. These factors may also change over time. Is it not, therefore, the case that just to look at 2 quarters and to try and do a comparison is not really the most robust way of doing this? Is it not better to actually reflect on this bill, the changes it's seeking to introduce, and to actually realise that it is going to make a significant difference in the medium to long term?
2 quarters is a significant amount of time. It is a record. You might not be comfortable with it, but the number of people you are returning who are arriving here legally is going down significantly. It's a fact. This clause matters. More than 742,000 people will qualify for indefinite leave to remain in the next couple of years. As we've said, this could cost my constituents and yours around, well, £8,200 per household. That's a significant cost to people in my part of the world. So for my constituents and that cost, I'd like to put it to a division, please.
New clause 25 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye. Aye. To the contrary, no. No. Division.
Jay Potterill.
No.
Dame Angela Regal.
No.
Becky Kittens.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White. Nick Wishart.
No.
The ayes were 2, the noes were 13. So the noes have it, the noes have it. Unlock. We now come to new clause 26, with which it will be convenient to debate new clause 43. I call Matt Vickers.
Thank you very much, Dr. Merson. The Labour Government Border Security Bill repeals sections 57 and 58 of the 2023 Illegal Migration Act, which concerns scientific age assessment methods. The Conservative Party completely disagrees with this decision. Every European country, apart from ours, uses scientific age assessment techniques, such as an X-ray of the wrist. Although there are other methods, over 50% of those claiming to be children were found to be adults after an age assessment in the quarter before the election. Without a scientific age assessment method, it's very hard to determine their age. There have been cases of men in their mid-20s ending up in schools with teenage girls, which carries obvious safeguarding risks. This is why we put forward this new clause to ensure that scientific methods for assessing a person's age are used whilst also disapplying the requirement for consent for these methods to be used. This will ensure...
With regards to the diet of migrants before they come to the UK, can he tell us whether he expects them to have or to lack normal calcium?
Come again.
I will indeed. With regards to the diet of migrants who come to the UK, can he tell us whether he expects them to have or to lack normal calcium?
I think that, you know what, we've said there are several methods. If we are unhappy with one, we can use alternatives. This is something that British taxpayers want to see. They want to ensure that our classrooms are safe. They want to ensure that social care settings are safe. They want, yeah.
What are the other methods and how accurate are they?
There are a raft of methods. I'm very happy to be direct, but actually, in real terms, every other country in the EU is using this as a method. It's tried and tested, it's easy to criticise, it's easy to question, it's easy to find holes probably in a whole plethora of methods, but I think it's the right thing to do.
Thank you for giving way. What are the other methods and how accurate are they?
Well, we can debate the methods at length, I am sure. I think the responsibility to have a method, the fact that the rest of Europe is doing it, means it is something we should be doing. It's a basic opportunity to get on with it, to do, yeah.
The rest of Europe are doing free trade, but he doesn't want to do that. So I think we should reflect on Europe and what we actually want to import into our country. On a different question, with regards to bone age and the assessment that's involved, can he tell us with confidence, grounded in science, that it would be able to determine the range in the range for relevant ages? Can he tell me what the margin of error would be, for instance, for somebody who is actually aged 18 or 19, and what that assessment of bone density and bone age would tell if they posed to be 15 or 16?
What I can tell him is that these age assessments could go somewhere to ensuring that those 20 or 30-year-olds do not end up in a classroom beside a teenage girl. There is an opportunity there to have a power that can be used with all of the knowledge that the agencies would have to make an assessment that can be used, the science of which would be determined, well, the agencies can look at that in the round. They can make those assessments based on, we know people have turned up without any form of ID. We know that they turned up with. This is an opportunity to put a line in the sand, and where the agencies think it's the right thing to do, they can use it. Of course they'll use it in moderation. Of course they'll use it in the context of the question marks that are around any method that they would use to assess such ages. Where are we? Yeah.
How safe would be the procedures that he isn't telling us the names of when we are actually using them to detect whether somebody is a child or an adult, and how safe would they be, particularly if that person turns out to be a child?
I would trust our agencies to use them in context, to apply all of the other things that they might apply in any given context. This is another tool that agencies can use on top of all the knowledge that they might have of a person coming and what their age might be. This is something that we should have. It's an opportunity to give another tool to our agencies. It's the right thing to do. This is why we put forward this new clause to ensure that scientific methods for assessing a person's age are used, whilst also disapplying the requirement for consent for these methods to be used. This will ensure adults cannot claim to be children. This also gives the government an opportunity to undo the mistake of repealing the sections of the Illegal Migration Act and allow age assessments for those claiming to be children.
Yeah. I thank you for giving way. It's a privilege to serve under your chairpersonship. Given his concern is about children here, and looking back to the evidence session that we had where we heard from the Children's Commissioner and her concerns about unaccompanied asylum-seeking children and their long extended periods in asylum hotels and what that then left them vulnerable to in terms of organised crime, notwithstanding the mix of age ranges in those asylum hotels, why does he still stand by the fact that the Illegal Migration Act and the Rwanda Act should be still in place when they are part of the reason why those children were in those asylum hotels for so long?
I'll probably stick with the clause and the age assessments. This is a tool. It's not something that's going to be used unabated. It's another tool that our agencies, with whatever other assessments they might make, can use. We are giving them the opportunity to require people to do that. That is a good thing. That's why the rest of Europe are doing it. I think the agencies, the experts, the professionals on the front line dealing with these very troubling, difficult cases should have all the tools they could possibly require to handle them. Therefore, I see no reason why we prevent them from doing this.
I appreciate his desire for our frontline staff to have all the tools that they need, which is why this bill is expanding the number of tools. But they are the tools that are being requested by frontline staff. Now, we could have scientific age assessments, and the government is certainly not saying that they are ruling them out entirely. There's work going on in the Home Office to consider the efficacy. We could have scientific age assessments, but is it not right that we need tools which are actually going to achieve the goals that we set our frontline staff? So with the Royal College of Paediatricians saying that in practice, age determination is an inexact science where the margin of error can sometimes be as much as 5 years either side. With myself not being a scientist or a member of the Royal College of Paediatricians, I'm assuming the same is true of the Honourable Member for Stockton West. Is it not better that we listen to expert bodies such as this Royal College, and as a consequence, we develop policy in line with that, rather than just saying, because Europe is doing it, we ought to do it?
I know we stood, that's a safe assessment of my scientific qualifications. I think in real terms, though, we were not saying this is the line. This is the only thing that these people will be able to use. It's something that can be used by those agencies, those experts on the front line who deal with these cases day in, day out. If we've ended up with situations where there are adults in classrooms with children, it's wrong, and we need to give them everything every tool in the armour to make sure that we can make that work. This is one such thing that they can use with their knowledge and with every other assessment that they would make. It's the right thing to do. We're talking about kicking it down the road. We've talked about the fact the government, well, I think we've got a commitment that the government will do something on it someday, sometime, but actually here it is. There's an opportunity to keep it in the legislation, to keep the power there for those agencies to use it here and now, rather than in 6 months, a year. I'm sure the Minister's going to give me a time frame on when the government will come back with such a power. The SNP's new clause is almost the polar opposite of our amendment, mandating that a person who claims to be a child must not be treated as an adult by the Home Office for the purpose of immigration control. We know that there are adults coming to this country who are claiming to be children. They are not. To believe them without question makes it harder to control our borders and creates significant safeguarding concerns. Why do the SNP think it should be made harder for the government to determine the true age of those entering this country illegally? How does this best serve the interests of the British people? Given the SNP's blind adoration for the European Union, it must be questioned why they're happy for the United Kingdom, of which Scotland is a key part, to be the only European nation that is not using medical tests to determine the age of those coming to this country. Why does this matter? It's not an issue which has decreased. The number of asylum age disputes remains high, particularly in the latest figures we have available. One of those where a dispute was raised and resolved, over half were found to be over the age of 18. The fact that we continue to see record numbers of asylum seekers pretending to be children should be the wake-up call needed to ensure that we have the checks in place to verify and stop those seeking to deceive from entering the UK. As the figures that are available show, this tactic is becoming commonplace and action must be taken to stop this abhorrent abuse. If the figures were not evidence of the need to support New Clause 26, then perhaps the facts of cases will. We've seen the case of a 22-year-old Afghan had murdered 2 other people in Serbia before he claimed asylum in the UK by pretending to be a 14-year-old orphan, when in fact he was actually 18. And then there's the utterly horrific case of the Parsons Green terrorist Ahmed Hassan, who posed as a 16-year-old before setting off a bomb on a tube train in West London, injuring 23 people. While his real age remains unknown, the judge who jailed the Iraqi for 34 years in 2018 said he was satisfied the bomber was between 18 and 21. The clock is ticking. The crisis isn't slowing, it's surging. In Q2 2024 alone, 2,088 age disputes landed on the Home Office's desk. 2,088 claims where someone said, "Trust me, I'm a child." And by the end, 757 were amassed as adults. A staggering 52% deception rate. That's not a blip, but a blazing red flag. That's over 750 grown men, potentially dozens more uncaught, slipping through a system Labour's crippled by repealing the Illegal Migration Act's scientific age checks, leaving us guessing in the dark while the numbers climb. Rewind to 2022.
The Honourable Gentleman.
Yeah.
And thank you. I thank him for giving way, and I'll deal with some of the broader points in my response to the wider debate. But we do age assessments. We're not just accepting, as his government didn't, what asylum seekers say their claimed age is, as if that's truth. So I wouldn't like him to give the impression in our proceedings that somehow that is what's happening and we're accepting claimed ages without any kind of checks. Dr. Morrison, I'll go into much more detail in my response to the overall debate about precisely what we do, but he mustn't give the impression that we're not checking. We are.
I would hope that you would agree with me that we need to be doing more rather than less. We need to give these agencies all the opportunities and the powers they can have to do so, even with or without the consent of these people who are aiming to deceive. This is the right thing to do. Rewind to 2022. 490 disputes in Q1, ballooned to 1,782 by Q4. Now we're at 2,088 and counting. This isn't a fading headache, it's an escalating emergency, a conveyor belt of fraud that's clogging our borders and spilling into our schools. Failure to have these vital checks would mean we're not just blind, we're complicit. Handing traffickers a playbook. Send adults, call them kids, watch us flounder. The public sees it, parents feel it, and every day we delay, the risk festers. We need science, not sentiment, and we need it now. Thank you.
Age assessments, use of scientific methods.
The question is that new clause 26 be read a second time. People shot.
Thank you very much, Dr. Morrison. I beg to move my Amendment 43 on age determination by the Home Office, and I think one thing we can agree on with the Conservative front bench is that my amendment couldn't be more different and objective in tone than what we've seen and heard from the honourable gentleman. At its core, what my amendment does is to uphold a simple yet vital principle that no child should be wrongly treated as an adult subjected to detention or placed in inappropriate accommodation, as happens right now. This amendment ensures that the Home Office only treats an individual claiming to be a child as an adult in exceptional circumstances or following a Merton-compliant age assessment conducted by local authority social workers. And furthermore, any decision to treat a young person as an adult must be made by an appropriately trained official with reasons recorded and subject to independent oversight. Where such a decision results in the person being placed in adult accommodation or detention, the relevant local authority must be notified immediately. And Labour members are right, and they're right to have a go at the honourable gentleman. It is absolutely imperative that we get this right. This is life-determining and life-shaping for the individuals that are at the sharp end of these age assessments, and the consequences of flawed age assessments at our borders are severe. Recent data reveals that between January and June 2024 alone, at least 262 children, 262 were wrongly assessed as adults and were then placed in adult accommodation or detention, exposing them to significant safeguarding risks, including exploitation, violence, and even criminal prosecution. And it's worth noting that in many cases, these children endure months of uncertainty before being correctly identified and moved into appropriate care settings. Such errors not only violate child protection principles, but also undermine the credibility of our asylum system. The current process of visual assessments, often conducted by the border by immigration officers, is wholly inadequate. Assessments based solely on appearance and demeanour are inherently flawed and have led to serious misjudgments. International and domestic guidance is clear that age assessments should be undertaken only when necessary and should be conducted using holistic, multidisciplinary approaches, yet this is far from the reality that is currently taking place. And concerns about visual assessments have been raised not just by NGOs, we've heard from the Children's Commissioner about all of this, but by the Independent Chief Inspector of Borders and Immigration, the Children's Commissioner, we heard, parliamentary committees and the UN Committee on the Rights of the Child. In response to these great concerns, the Government has argued that it's improving the age assessment process through the National Age Assessment Board and the introduction of scientific methods. We're back to this debate again of assessment age. It's important to note that neither of these initiatives has any impact on visual assessments made by officials at the border. Biological methods such as dental x-rays and bone age assessments remain highly unreliable, as medical and scientific bodies repeatedly state. And I listen to the Honourable Gentleman who would like to make much play on this. This is what all of Europe does. There are countless cases of where the EU and other European nations have got them wrong. I'll send it to the Honourable Gentleman. He could spend most of the day looking at them, but they get it wrong, just as we are getting it wrong with visual assessments too. It is right in this bill the Government is seeking to repeal clause 58. It's right that they're doing it, which would have meant that children who refuse to undergo these invasive and questionable procedures will be presumed to be adults by default, an approach that runs contrary to any safeguarding principles. The previous government attempted to justify these policies by highlighting the risk of adults falsely claiming to be children to access benefits and services designed for minors. However, the reality is that the greater danger lies in the wrongful treatment of children as adults, which places them in unsafe environments, denies them their rights, and can have devastating long-term consequences. And it's true that the number of children found to have been misclassified as adults outweighs the number of cases where an adult has falsely claimed to be a child. We've got the balance totally wrong when we're doing this and the outcomes of these assessments. Crucially, there are greater risks and consequences when we place a child amongst adults when there are no safeguards in place compared to when a young adult is placed in local authority care. It's essential that we restore local authority-led age assessments as the primary mechanism for determining age disputes. As child protection professionals, local authority social workers are best placed to conduct these assessments in a manner that is thorough, fair and in the child's best interest. This amendment ensures that young people asserting their children are treated as such unless and until a proper assessment proves otherwise. It also guarantees transparency, independent oversight and accountability in decision making, thereby restoring trust in the system. This isn't an immigration issue. It's nothing to do with immigration. It is a safeguarding issue, making sure that we have the best interests of children at heart. It's an opportunity to uphold our commitment to child welfare and to ensure that the UK meets its obligations under domestic and international child protection frameworks. I urge colleagues to support this amendment, ensuring that no child seeking refuge to this country is wrongly treated as an adult and then placed in harm's way.
Thank you, Dr. Morrison. On the 23rd of January 2023, Lawangeen Abdul Rahimzai, I can say this name and I have practiced it. Lawangeen Abdul Rahimzai was sentenced to life imprisonment at Salisbury Crown Court. Nearly a year earlier, Abdul Rahimzai had murdered 21-year-old Thomas Roberts in Bournemouth town centre. He stabbed him to death in the street following a dispute over an e-scooter. Abdul Rahimzai was an Afghan asylum seeker who came to this country in December 2019. He entered the UK illegally, claiming to be an unaccompanied 14-year-old. He was placed in school. He was placed in foster care. But he was, in fact, already an adult when he came here. Indeed, not only was he an adult, he was also a murderer, having killed 2 men in Serbia before coming to the UK. He should never have been allowed to come to this country, and he should certainly not have been allowed to masquerade as a child. Assessing a person's age is surprisingly difficult, but we have a range of tools to do so. The Home Office is just not using them. If we had acted sooner, using the full suite of tools at our disposal to assess Abdul Rahimzai's age, Thomas Roberts might still be alive today. The case of Lawangeen Abdul Rahimzai is particularly shocking, but unfortunately it is far from unique. Ahmed Hassan, an Iraqi asylum seeker, claimed to be a 16-year-old when he arrived in the UK. Gladly.
Thank you, Sir. I wonder, have there been any new scientific discoveries in the last 7 months on identifying someone's age that the Home Office wouldn't have been aware of over the last 14 years? Or is it not that the methodologies that we use are very imprecise and don't actually often lead us in the liminal cases to drawing the distinctions the Honourable Lady is advocating for?
Thank you. I thank the member for his intervention. I will come on to precision and ways of determining slightly later in my remarks. I will go back to the beginning of my previous sentence. Ahmed Hassan, an Iraqi asylum seeker, claimed to be a 16-year-old when he arrived in the UK. In 2017, he set off a bomb at Parsons Green Tube Station, injuring 23 people. His real age is still not a matter of public record. In 2018, a Home Office probe found that Siavash Shah, an Iranian asylum seeker, spent 6 weeks as a Year 11 pupil in Ipswich, despite being 25. The list goes on and on. In fact, between 2020 and 2023, the Home Office identified almost 4,000 cases of adult migrants claiming to be children. That amounted to 45% of those who originally claimed to be children when they arrived here. Every other person of that cohort was in fact an adult, and some were at least 30 years old. This puts British children at risk, it puts genuine child asylum seekers at risk, and takes valuable school and care places away from young people who genuinely need them. I feel this particularly keenly as a Member of Parliament for Kent, the county into which all small boats arrive. Our laws mandate that people who come to this country illegally and claim to be under 18 must be prioritised for care equally with Kentish children. This puts enormous pressure on the system, and makes it harder and harder for our children to be cared for. This is madness when we know that half of those arrivals are in fact adults, and we must put a stop to it. It is completely rational, albeit of course morally wrong, for adult migrants to claim to be children. Those under 18 who come here have greater entitlements to care and support, do not have to live in accommodation with adults, and are not subject to the same rules as adults, all those rules are applied less strictly. Of course, there are people who cross the channel without their parents who are under 18. Most, though not all, are male 17 and 16-year-olds. Some are younger children. Nobody disputes that, and children should be treated as children. But we must be realistic about the scandalous degree to which our system is exploited by the cynical and the sinister. We have to protect actual children, and we should use every tool in the box to do so, including scientific testing. Where people refuse those tests, the government should be able to override that refusal. We are acting in the interest of public safety and to protect the security of our children. Honourable members opposite asked for exact details of scientific methods. These are, as my honourable friend, the member for Stockton West, has set out, many. There are several different ways of doing this. Most of those which can be implemented in short order are dental and skeletal. There are other methods currently at an earlier stage, like facial age estimation and DNA methylation, which is a process by which people much cleverer than I can assess how a person's genes are read by their body, which changes with age. As the Interim Age Estimation Science Advisory Committee said in 2022, the teeth, clavicle, hand and wrist or knee, and I quote, have been shown to have a significant research and publication credibility and provide a consistent age range over which changes occur. Later, the report says the committee has relied on areas and methods that have been repeatedly tried and tested and shown to have consistency. As is clear in those quotes, and honourable members from the benches opposite have also said, scientific age assessment is not perfectly precise. It is not magic. But as my honourable friend, the member for Stockton West, also correctly says, our proposal is not that scientific age assessments should be used to replace other methods and judgments, but to supplement them. The situations I and my honourable friend have set out are horrifying. We can see no reason why the government would not want to have the widest set of possible tools available to them to stop this happening, including the option in the future to bring in scientific methods that are currently in nascent stages.
Thank you, Dr. Morrison. And I thank the honourable member for Weald of Kent for raising the absolutely horrific and awful circumstances involving Thomas Roberts, who would have been a constituent of mine, whose mother Dolores is a constituent of mine, and who is racked by grief, who is unable to sleep at night, whose health has worsened because, as she said to myself and the minister last night in the minister's office, she feels like with her son being murdered, half of her whole life has just completely disappeared. And I don't want to name the murderer in this debate. I want to name Thomas Roberts, the victim, and I want, with your permission, to briefly just talk a little about Thomas Roberts, because I think it's important for this committee to know who he was. And I think it's important for Dolores, so racked with grief, to be able to know that her MP in this committee is focused on what happened. Thomas was 21 years of age when he died on the 12th of March 2022 in Bournemouth Town Centre, the victim of a stabbing by an asylum seeker. His mum has told me this several times, and she told me again with the minister last night how Thomas was known by everybody. How when his mother wanted to go into town or to Littledown or to other parts of the constituency, he would say no, because he was so well known and he didn't want to be seen with his mum out by his friends. How he was an aspiring Royal Marine, and in order to become a Royal Marine, he was in the Sea Scouts. How he was physically fit, so fit in fact that he would actually bench press his mum and his brother. And how that, but also his passing of his driving test on the first go, was one of the proudest moments of Dolores. It's one of the things that she remembers so fondly and so closely now as she is coming to terms with that grief. He was an aspiring DJ, a drum and bass DJ, by all accounts, a very, very good DJ. He was an up-and-coming DJ in the South Coast, and if he hadn't made it as a Royal Marine, and there was every certainty that he would, he could easily have taken up a career as a drum and bass DJ. And he was a member of the Christchurch Boxing Club. He was active in his community. He was deeply loving and caring about his family. And he lost his life, rather his life was taken from him because an asylum seeker was in our country. And it begs the question, why was that person in our country? Why were they able to wield the knife that cut short Thomas Roberts' life, that took away all the hopes and ambitions that his mother had for him? Well, it's because we didn't have access to the necessary database in order to track the criminality and find out more about who the asylum seeker actually was. And so I'm deeply sad that Thomas isn't with his mum, isn't in his community, isn't with his friends who loved him so much, because the last government broke our asylum and immigration system and created the conditions for this tragic killing, but also the other tragic killings that have happened in our country. And scientific age assessment, as the member for Weald of Kent has said, is not a magic wand. It's imprecise. We've heard from the Royal College of Paediatricians. We know what works. We know having a functioning asylum and immigration system will make all of the difference. And I just wish that we had had that on the 12th of March 2022, when Thomas lost, or again, was denied his life opportunities because of the breakages in that system. And I thank the Minister for meeting yesterday with Dolores. I know that it provided her with much needed comfort, much needed clarity, and I'm absolutely confident that this bill and the measures within it are going to make the difference that is so needed to protect our society. I also just want to note the contribution of Councillor Joe Salmon in Bournemouth, Christchurch and Poole Council, who has been such a support to Dolores and the wider community around her, because she will be grieving for a very, very long time. And it is incumbent on all of us in public service to speak the truth, to look at the facts, and to actually bring forward the measures that will make the biggest differences. And if I may then, with your patience, just return to the question of scientific age assessments. I have already stated the concerns of the Royal College of Paediatricians. I've stated concerns of experts. I have not, but I will now state the concerns of the House of Lords debate that took place on the 27th of November 2023, which is really worth a read if nobody has had a chance to read it yet on the opposition benches. It goes into significant detail and depth about the concerns that are had about this as a possible policy at that stage of its development. The Minister has been really clear that scientific age assessments are not off the table. There just needs to be certainty that they're an effective tool. And I think what we all need in our country to avoid any further deaths and any further injustices is to have the right tools that will protect the people of this country, secure and protect our borders, and make sure that we are truly able to restore confidence and trust in this system, and restore trust and confidence in our ability as a country to manage who comes into our country and who stays here.
Thank you, Chair. I would just like to start by thanking my honourable friend for Bournemouth East and also the honourable member for Weald of Kent for what I believe has been a really respectful part of quite a heated discussion and has done honour to Dolores and her family at what's clearly an incredibly difficult time. I think it's really poignant that case studies like this are discussed in these debates. They show us what can happen on the limited and rare occasions that things do go incredibly wrong with systems like this, and it's worthwhile that we have these discussions. However,
I must say I was disappointed in the contributions to support this new clause by the opposition, because where they did very successfully focus on those occasions where things have gone wrong, they were very limited on detail. And I was also quite disappointed at the sort of lack of ability to answer the question by my right honourable friend from Edinburgh East and Musselburgh. We do need that detail, and we do need to understand what would make it different from, you know, what has been in the tool, the sort of arsenal of the Home Office over the past 14 years in their government. Now, this level of indecision when we're discussing new clauses to go into a bill is quite concerning. Its inclusion, in my view, would leave this bill, or sort of render it inachievable and potentially undeliverable. Even to, you know, if we want to see an example of where this happens, where we are putting things into bills that we don't think are workable, we just need to look to the Illegal Migration Act and how defunct that ended up being. Now, I don't propose to make big political points about this, Chair, because I don't think I need to. I think the previous Conservative government made those points for themselves in their failure to actually commence or implement a lot of the Illegal Migration Act. We had 34 major clauses that were passed by this House that were never commenced because ministers knew that they wouldn't work. There was a further 16 clauses that were commenced but never operationalised because they were simply unworkable. And so, Chair, my point in rising on this new clause debate is to say I really feel we should be considering what this bill is about and reminding the committee that this bill is about action. It's about making sure that what comes out of the end of this committee session is a bill that is workable, it's operational, and it does the hard work to tackle the criminal gangs that are fueling illegal immigration and fixing our broken asylum system. Thank you.
Thank you, Chair. I rise really just to say what a privilege it is to hear about Thomas Roberts' life. The Honourable Member for Bournemouth East does himself great credit in telling us about him so movingly. And Thomas's mother, Dolores, whose pain is impossible for us to imagine, does his memory great credit in finding a way in her grief to talk about her son to her Member of Parliament and to the Minister. Securing the border is a genuinely difficult job, and we are genuine in our desire to support the government in doing it. We really believe that this would help the government expand its ability to do that job, and we deeply hope that they will consider it. And just before I sit, I would also like to thank the Member for Clwyd East for her earlier words. That was very generous of her.
Thank you very much, Dr. Morrison. I want to start just by endorsing what the Honourable Member for Bournemouth East has said about Dolores, who was Thomas Roberts' mum, who I met last night, who has gone through a searingly awful life experience. But it's very difficult to even think about, let alone be able to offer any comfort. I don't think her experience would have changed very much, unfortunately, had scientific age assessment been in place, although this person had been assessed by his local authority as a child and was therefore in a separate environment to the one he would have been in had he not been assessed as a child. But I do think, and I'm determined to look to see whether we can connect up our information about people coming from Europe following Brexit and the disintegration of our access to Eurodac and various other pieces of information collected in Europe on asylum seekers and those that are arriving illegally. Not all of them are asylum seekers. I think reconnecting, if possible, to those databases would give us more comfort than we have at the moment. Although I'd like to emphasise that when people come into this country, we do check them against all of our biometric records and the terrorism lists and the watch lists that we have. But I feel that it may be possible in the future for us to be able to do more. I think we've had a debate about new clause 26 from the opposition and new clause 43 from the Right Honourable Member for Perth and Kinrossshire on behalf of the Scottish National Party that again demonstrates the wide range of opinion at both ends of the argument whenever we consider these kinds of issues. And I'm going to deal with both of those arguments in my response, and I hope find a middle way. Firstly, section 58 of the Illegal Migration Act, which this bill before us will repeal, does not stop our capacity to do age assessments. And listening to some of the contributions from honourable members from the official opposition, one would have thought that ending Section 58, repealing Section 58 of the Illegal Migration Act would take off the table completely and utterly all age assessments. That simply isn't true. The age assessments which were mentioned in Section 58 of the IMA were about the duty to remove to Rwanda. They weren't connected to anything else. And the issue, as I understand it, with that piece of legislation was that the then government's intention was not to remove children to Rwanda, and therefore it became more important to try to have a way of assessing whether somebody was a child or not. Simply, the Safety of Rwanda Act and the IMA, which was the previous government's approach to this, would have created even bigger incentives for people to claim that they were children, because by doing that they would have avoided being sent to Rwanda if anyone had ever actually ended up there, and we know they didn't. So the previous government's approach to deportation permanently to Rwanda actually created even more incentives for people to lie about their age. And the fact is, there are people who are genuine asylum seekers, there are children, there are people who aren't genuine asylum seekers, who are adults, who claim they're children, and there are actually children who sometimes claim they're adults. Particularly when that happens, one has to look at modern slavery issues and coercive control. So there are safeguarding issues on both sides of these age assessments for children pretending to be adults for reasons that you or I can imagine that we're not going to go into in this committee, Dr. Morrison, but they're not very pleasant. And there are also the incentives created by the way that the Children Act deals with unaccompanied asylum-seeking children, and the honourable member of the Weald of Kent, as a Kent MP, knows exactly what happens with the Kent intake unit, and exactly the pressure that her own local authority has been put under, but also the government support that her local authority has been given in order to disperse unaccompanied asylum-seeking children around the rest of the country, so some of the burden can be shared. So we are dealing here with people who arrive without papers, some of whom are wishing to lie about their age, some of whom have been told to lie about their age because it's perceived by the people smuggling gangs as a way of them being able to access more resources than they would be able to access if they were seen as adults. The system, as the honourable member, the gentleman, the member for Perth and Kinrossshire has pointed out, can get it wrong on both sides. People who are children have been judged to be adults and put in inappropriate places, and people who are adults have been judged to be children and put in inappropriate places. And when there is no guaranteed scientific way of making a judgment, can make judgments about people who are much older, but it's that 4 to 5 year range on either side. And Dr. Morrison, you'll know about all of this from your profession as a medical doctor. It's that in uncertainty and that 4 to 5 year age range, which is the difference between 18 and 24, or 17 and 23, with which we're dealing here. Now, new clause 26, I just wanted to reassure honourable members opposite that there's already provision in law for the use of age assessment, and our repealing of section 58 does not remove the provision that exists already in law for using age assessments. And that is because the Immigration Age Assessment Regulations 2024, which followed scientific advice from the Age Estimation Scientific Advisory Committee set up in the Home Office, specifies for the purposes of Section 52 of the Nationality and Borders Act 2022 the methods currently recommended for scientific methods of age assessment. We've retained those bits of legislation, neither of those, neither the regulations nor the section 52 of the NABA, the Nationality and Borders Act, have been repealed in this legislation. So the capacity to use age assessments, scientific age assessments, remains on the statute book. So I think that when we look at what those regulations specify, because the honourable gentleman opposite in his remarks didn't seem to know which methods we were talking about. It's the power to use X-rays and MRIs, and to take a negative influence into the credibility of a person who refuses to consent where there are no reasonable grounds for refusing that consent. So with those on the statute book, the government continues to explore methods to improve the robustness of age assessment processes by increasing the reliability of the scientific methods used. And at the moment, we don't have enough certainty about that gap to bring, with the current assessments, they're still being assessed. The Honourable... I will, but the Honourable Gentleman and his party put these things onto the statute book and then didn't operationalise them. We are actually at the moment doing as much work as we can to see how reliable they are with a view to operationalising them, but we're not, as I wrote in a response to the shadow Home Secretary when he wrote to me about this. We are in the middle of that process, and I hope that we'll be in a situation to make announcements one way or the other soon. And that those announcements will be made in the usual way, but I'm happy to give way to it.
So, with regards to the clause that we aren't specifying the method, I know we might have now, but this doesn't specify it. It commits the government to coming back within 6 months with an SI. How long does she think before the government will be in a position to do that? Is it 6 months worth of people here without that ability to assess them without consent using those methods, or is it a year? Is it 18 months? How long do we think before we'll be in a position to make those decisions?
We're making a scientific assessment of how accurate and effective the methods that could be used to make age assessments. We're making an assessment of how effective they are, and I'm hoping to have some results from that soon. What I don't want, Dr. Morrison, is to have a clause in primary legislation telling me I've got to do it by a set time. I'm trying to reassure the Honourable Gentleman that despite the repeal of Section 58 of the Illegal Migration Act, which this bill brings about, the capacity to do age assessments and apply age assessments scientifically is still on the statute book, and we are looking very closely into how we can operationalise that if we feel that it gives us a more trustworthy result. We won't do it if we don't, and we are in the middle of getting to the stage where that would be the case. I'd like also to address new clause 43, which basically says that we shouldn't use age assessments at all unless they're in exceptional circumstances. It does, I think, and given what the Honourable Gentleman was saying when he moved it, except that Merton assessments, which are the current other way of dealing with assessing age, which are interviews of the person concerned, usually by 2 social workers and various other experts, to try to get a handle on what their real age is, should continue. But what it would do, clause 43, is remove Home Office immigration officers' ability to conduct initial decisions on age at the border. Now, I mean, and I think that these are very, very important powers which enable us to try to get the system working as well as possible at Western Jetfoil and at Manston if people arrive undocumented on small boats. The initial decision on age is used as an important first step to prevent individuals who are clearly an adult or a child from being subjected unnecessarily to a more substantive age assessment, and to ensure individuals are rooted to the correct adult or child immigration process, and they do differ, as we all have been talking about in our debate this morning. There's no doubt, following the initial decision on age, that individuals are referred for further consideration. If there's doubt, they're referred for further consideration of their age. This amendment would mean, this new clause would mean that even those who are very obviously adults would need to be referred into local authority care for an age assessment, placing burdens on already stretched local authorities and causing significant safeguarding risks from adults having access alongside other genuine children to children's services, including accommodation and education. Merton assessments don't happen overnight. They take time to organise and in some ways have been so slow that the previous government actually created the National Age Assessment Board, which is a decision-making body of Home Office social workers who can conduct Merton-compliant assessments centrally. The National Age Assessment Board was launched in March 2023 and has now been made available nationally, and it continues to offer significant improvements to our process for assessing age. It currently employs over 50 social workers, with recruitment ongoing to increase capacity and expertise in the system. And I can assure all honourable members and honourable friends that National Age Assessment Board social workers are required to engage in a comprehensive training programme regardless of their previous experience. Successful completion of this allows them to become designated and conduct Merton-compliant age assessments on behalf of the National Board. Subsection 5 of Amendment 42 would require the Home Office to establish through regulations a new independent review framework to oversee age assessments. While there's no review body which inspects local authority decisions on age, I can't see the merits of setting up a new review framework for the Home Office when age assessment already falls within the remit of the independent Chief Inspector of Borders and Immigration. And the ICIBI has recently conducted an investigation on age assessment, and I look forward to seeing the report and its findings in due course, and they will then be published. So this capacity to oversee age assessments and how they're conducted already exists. Lastly, this amendment would require the Home Office automatically to notify local authorities where an individual is claiming to be a child and in adult accommodation, even where they've already been assessed to be an adult by the Home Office. This would include individuals who've been assessed to be significantly over 18. And I can assure this committee that, that where Home Office or accommodation provider staff have concerns that an individual might be a child, it's standard practice for a local authority referral to be raised. And even where a referral is not made by the Home Office service providers to the local authority, this does not prevent them from approaching a local authority for further consideration of that age. So I think a lot of these issues are covered, and I think the new clause 42 would make it harder, paradoxically. I'll give way to the honourable gentleman in a sec. That would make it harder, paradoxically, for us to try to get this right.
I welcome the fact that the government, my understanding, Welsh might clarify that the government will come back with scientific age assessments that also don't require consent. But if 6 months is too long, at what point would you expect to be concerned about that? If in a year, if we haven't been applying these and we've been ended up with the wrong people in the wrong classrooms for a year, is that the point at which we should be concerned? Is it 18 months? If 6 months is too soon, But at what point should we be concerned that it's taking
The
too long?
honourable gentleman is being a bit mischievous. I think that we are in the middle of having a scientific assessment of whether scientific age assessments work and to what capacity and to what detail we can trust them. I'm expecting reports fairly soon, and once I have reports, I can make a decision on how and in what way and in what form we can go ahead with them. I will let Parliament know in the usual way when that has happened, but what I don't think is useful or effective is to have his new clause on the face of this bill setting a deadline to that. And I hope that he'll accept that in the way in which way in which I intend it, which is to be helpful. We're not in disagreement on principles, but we do, if we're going to have to use scientific age assessment, need to ensure that it's as effective and useful as possible so that it can be taken seriously and play an effective part in the battle that I think all of us want to be involved in, to ensure that children don't end up in adult settings and adults don't end up in children's settings.
Matt Vickers.
Thank you, Dr. Morrison. People who arrive here deceptively claiming to be children cannot be allowed to succeed. We should make use of the best scientific age assessment methods available to us, with or without consent. Of course, this will not be used in isolation, but alongside all the other possible assessment methods available to us. You can debate the science all day. This clause allows for requires the Secretary of State to define those methods with the statutory instrument, using expert advice to do so within 6 months. One deceptive adult migrant sat in a classroom or a care setting alongside children or vulnerable youngsters is one too many. I believe giving our agencies the ability to use the best scientific methods available to them to assess age without consent can further their ability to protect children, and I'd therefore like to move a division.
Pete Wishart.
Just briefly, I'm grateful to the Minister for a response to my particular amendment, but a lot of it that she claims is in my amendment isn't actually there, and I hope she accepts some of that. And I think all of us who go to visit asylum seekers within our constituencies will recognise that age determination is probably just about the most contentious issue that asylum seekers bring to us. It's the thing that perplexes and concerns them the most, and they're very sensitive to this being done wrong, and it gets done wrong in both directions, as the Minister said in response. But the number of children found to have been misclassified as adults outweighs quite significantly the cases where a child has falsely, an asylum seeker has falsely claimed to be a child. And everybody's right in this. There's no scientific or any method to determine age which is 100% effective. We know all that, and scientific methods, certainly not visual assessments. But surely the people who are best qualified to make these assessments are people who work with children, that is their main business, to make these sort of judgments about children they're coming to. That's why we've asked for the Merton compliant age assessments, so that the holistic view of that individual is going to be looked at and will be assessed properly by those social workers who are trained to work with children. Surely that's the most effective means to determine this. Now, I'm not saying we don't use other things, but where it's in dispute, and I'm sorry, I looked at my amendment, and maybe I should have made it clear, where it's in dispute should have possibly done it. I mean, quite clearly the people sitting in this committee couldn't be classified as children, but where it is in dispute, we must get this right. It is so important as we go forward, and it's a life-changing decision to be misclassified, and the danger and damage that strikes. As I said earlier in my initial contribution, this isn't an immigration issue, this is a safeguarding issue, and surely we must get this right, and that's why I will be pushing this to a vote too, Dr. Morrison. Thank you.
New clause 26 proposed as on the amendment paper. The question is, the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Jade Cotterill.
No.
Dame Angela Regal.
No.
Becky Kittens.
No.
Tom Hayes.
No.
Katie Dam.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp. Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
The ayes were 2, the noes were 12, so the noes have it, the noes have it. Unlocked.
Beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye. Aye. To the contrary, no. The ayes have it, the ayes have it. Adjourned until 2 o'clock.